It is April 13th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Get ready for a night full of judges running out of patience. In today's compilation, every single judge reaches their breaking point. We'll see Judge Stevens deal with a smart Alec who thinks he can run the courtroom. Then Judge DiSanto shuts down a defendant's absurd excuses about gas money. And well, Judge Dad is literally fed up with everyone he sees tonight. But you absolutely have to stick around for Judge Mogen, who catches a witness in a blatant lie carrying nearly $500,000 restitution here. These judges have had enough, ladies and gentlemen, and it all starts right now.
You're Darren Woods,
Yes, sir.
and you're here with your attorney, Mr. Dusler, and the state's attorney is going to be present. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
So he's an habitual felon here. What are we doing?
Count one.
Just one?
Yes, sir.
I guess there's a good reason for such benevolence because you're looking at a minimum 25 years in prison. Why would we go below that? I know there's a good reason. I don't know what it is. Somebody speak.
Yes, sir. Yes, sir. There's a good reason. We just felt that under the circumstance with the allegations here that he was not necessarily in a proper mental state at the time. It probably would not have happened. Otherwise, we feel like this is appropriate.
Pick it up. I read this probable cause affidavit. Does everybody agree it's very disturbing?
It is. And
He threatened to kill people. The police officer. My goodness. He's a habitual felon, and we're going to lighten the load?
well,
Whatever. We open the door for one. We open the door for everybody. What's special about him that everybody's going to be able to walk through the open door for? How can you threaten to kill people and then as an habitual felon and then mitigate any punishment? And see, he'd be at my house to sexually assault him and his wife.
Again, this occurred in the police car after he had been arrested.
Yeah.
He felt like he had been wrongfully detained at the time. He was not.
So quite naturally threatens to kill and sexual assault.
He was
people.
not in a proper state of mind, and he said.
What does that mean?
He said those
Was he insane or not?
No, sir, but he said those things out of anger at the time for being picked up when he didn't realize, he didn't believe that he should have been stopped. And he didn't intend to, he didn't mean to.
How do you know that?
We,
I know you're advocating, but he said what he said.
Yeah.
He certainly intended to say it.
well, a lot of people say things in anger. My
Thank
wife threatens me all the time in anger,
But
and she means it sometimes.
has she ever said this to you? To kill you or sexually assault you?
Maybe the former part.
No, I know her. She wouldn't do that.
Anyway, we feel like this.
And it would be in jest anyway.
Yes, sir.
Not that you don't deserve a good finger pointing by the wife sometimes, but no, this is very disturbing, especially somebody who's looking at habitual felon status. My goodness, you don't threaten people. They work for you anyway. The police work for you. You might as well threaten yourself in the mirror. Burglary of a habitation and then robbery. That means convicted of a violent crime. Here's what we're going to do. The state's going to communicate with the victim here again and see what the input from the victim and the officer. And we're going to reset this for 2 weeks. You come back in 2 weeks and then we'll make a decision on what direction we head on this. Do you understand? Do you understand? Speak. Do you understand? We're going to reset for 2 weeks. You'll be back in 2 weeks after I get input from the victim. They're entitled to be heard. And I want to know what the victim has to say about this proposed sentence. They have a voice with me. Do you understand?
Yes.
You have to speak out so she can hear you, sir, and put it in the radio. You're nodding. Speak out. Yes, yes. Okay, good, good. That's all. That's all I
He's
need.
not going to make a decision today.
Yeah, I'm
We're
gonna
going to come back in a couple of weeks.
We're going to come back in 2 weeks, and I want the victim to be heard. So I want his input in my decision, which is what the law states should be done. Just not you. It's the victim is also the person who is harmed.
I know, I was just saying, if you gave me a chance to speak, you would steady talking instead of listening.
In 2 weeks.
You're held in contempt of court, Mr. Smart Alec.
Whatever you say.
Yes, sir. Yes, sir. And that's what it is. That was abusive and it was inappropriate. And only one of us can speak. You continue to be rude. You will be held in contempt, sir, and we'll take you up later. Thank you. And if it was a crime for being rude, that'd be another offense. Okay, what?
It's the next one, I think it's Vargas.
Alex Vargas.
That's
Alex,
he's in the back.
he's coming up to the front. Vargas. Vargas.
Vargas. And we sent him to you too.
I'm gonna send you a Christmas gift too, something.
Yeah, that'd be good.
Come forward. Does he need to be in front of you? Please come forward in front of that lady, sir. Thank you very much.
Vargas, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, each of your lower right thumb front. Okay, turn it flat right down the wall. Each up one more time. Do it flat. Don't roll it. Okay. Right there.
Let's still in school.
Yeah, we're at the,
Okay, there you go. You go sit from.
we're in the ancient times here.
I not wrong with this.
Back when she does the records and file them, she uses like a hammer and a chisel.
That's it for right now.
It's slow, but it gets the job done. It works.
Done.
It's old school stuff.
Ain't nothing wrong with that.
24 CR 2410 is called the State of Texas versus Alex Vargas. Is that you?
Yes, Your Honor.
Present with your attorney, Mr. Adams, and the state's attorney is here. Does the defendant waive a formal reading of the indictment and the arraignment in this case? Can we proceed in summary?
Yes.
In summary, sir, this indictment alleges that on or about September 19th, 2024 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger, a child younger than 15 years of age. Do you understand what you're charged with?
Yes, sir.
That was your 12-year-old daughter,
Yes, sir.
and it's a 4,000-pound missile. That's what a vehicle is. You got to operate it sensibly, responsibly, and certainly you don't put people in harm's way like you're. I'm sure you love your daughter.
Yes.
You would, well, put her in jeopardy, and you and everybody else when you were intoxicated here. What was the intoxication level?
I think it was
I don't ever get that.
0.188.
0.188. That's over twice the legal limit, over twice. If convicted, you face a confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. There would be terms and conditions of probation which are normal and customary for this type of offense. It also states restitution would be determined by the court for what?
Judge, there was an accident involving another vehicle.
Did you have insurance? No. That's a crime too, to operate a motor vehicle without liability insurance. What happened in that case? What's that? Did they file something on that?
I don't believe so,
Anybody?
Judge.
What's the restitution?
We're not sure. I've spoken to probation about reaching out to the driver of that other vehicle to get that.
We're gonna do a post-sentence report on this?
Yes, sir.
Because he needs to get on probation as soon as possible so he can not only get out, but also start working on restitution. All right. You'd be found guilty, placed on probation for 5 years. There will be terms and conditions of probation which are normal and customary for this. Also, according to, I don't even have anything about
Yes, Judge, we have not been able to
correct
determine,
identity yield.
but there was another vehicle involved in the accident.
There are going to be a lot of probation terms here, which are typical for this kind of situation. You not only were intoxicated, you had a child passenger while intoxicated, plus you had a collision with another vehicle. If I follow this agreement of sentencing you to 2 years, probated for 5 years, also, you're going to have to do some jail time on this. That's just normal and customary for this.
Judge, I don't believe for a DWI child passenger, there's any mandatory jail time.
Yeah, I'm sorry. He's going to jail on my watch. My goodness, yeah, you can't put people in harm's way, especially a child, your own child that you're supposed to be taking care of. No, you're going to go to jail. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? That's a yes or no statement.
Yes.
Okay. I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document? Understand it? Discuss it with your attorney or the contents all true and correct? Yes. State's Exhibit 1 is tendered into evidence.
No objections.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1, part of the record for all purposes. Can you figure out how much time he has already, please?
Currently been in custody for 66 days.
Yeah, see, for a regular DWI, what is the normal? They handle that misdemeanor. Is that, how much time do they serve on a DWI?
On a second DWI, I think it's what, 3 days?
It's mandatory 72 hours in jail on a DWI second.
On second,
On DWI second, it's a mandatory 3
right, well, on first.
3 days.
And a third, there's a mandatory amount of time as well.
10.
I believe it's 10.
Yeah, 10 on the third. What you got is child. My gosh, that's just Anybody figure out something more important than that? Your own child. All right, once again, you pleaded guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle with a child passenger. And you were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. Now, there are going to be terms and probation which are not only normal and customary for this type of offense, but also special for the circumstances of this case. Restitution is ordered to be determined because you caused a collision with another vehicle while intoxicated. Your fault. You got to pay for it. I don't know what that is going to be, but we will determine it. But restitution will be ordered. We will take that up, the exact amount at a later hearing, unless the parties can agree to it. You must complete a DWI education program, and you will serve 30 days in jail or as a condition of probation based upon the fact that a child passenger was in the vehicle that you operated while intoxicated, which is irresponsible behavior, especially your own son. I shouldn't have to be telling you how to take care of your children.
I understand, Judge.
You understand. Fix this. Don't do that.
Yes, sir.
Something would have happened bad. She'd gotten hurt or worse. I can't even imagine carrying that around in your mind your whole life, knowing that it was your fault, you know? That's why you don't want to have to live with that kind of torment. Just do the right thing. But most importantly, you made this a big mistake here in this. You collided with other people. You had your own child in the car while you were intoxicated. You're third in all of this. We all are, right?
Yes,
Our creator is first.
Yes.
Others are second. Then we show up third in the great importance of things. That's the way it should be. That's the responsible way of thinking, and that seems to be a good method of living a responsible, selfless life and not putting people unnecessarily in harm's way. Okay.
Yes, sir.
I think you understand and appreciate that.
Yeah.
Just follow that.
I will.
Okay. Anything else? That is all. Thank you.
Good luck. Sir, I say just good luck. Good luck. Okay.
You got a job during the day? Do you have a job, a position? You work?
Yeah, work, your job.
Working?
You work somewhere?
Yes, sir, at a mechanic shop.
This jail time can also be done on weekends if he needs to keep his job.
It's up to you, Ron.
Do you work during the weekday, Monday through Friday?
Yes, sir.
Okay, you can do the jail time over weekends if you want, or you can do it day for day and get it over with. It's your call. I don't know how
I get back to work.
you need to keep your job for your family. If that's what it takes, then you can check in 6:00 p.m. Friday. They let you out 6:00 p.m. Sunday. You get 2 days credit. What I say, 30 days? Then that would be 15 weekends, but it keeps your job and keeps you taking care of your family.
Yes, sir. Yes.
Okay.
Do that.
All right. Then you can report then on PM this Friday.
Yes, sir.
And then every Friday thereafter until the 30 days are covered. Okay,
Okay.
all right.
Yeah.
Good luck. Yes, sir. Tasha Landry?
Yes, sir.
Hi, Miss Landry. 23 CR 2015 is called Tasha Latrice Landry. And you were here with Mr. Adams, your attorney, and the state's attorney will be present. The probation office is here. There is a motion to revoke probation that was filed December 9th, 2025. Are you familiar with it?
You been familiar with the one?
Yes, sir.
You've discussed this
Yes,
with
sir.
your attorney. Y'all are ready to proceed today?
Yes, Your Honor.
Is there an agreement on this?
No.
I don't see.
When I was looking at count one of the motion to revoke,
Yeah.
I'm not sure that that clearly states what that means. I was looking at it that when we were talking about pleading to it.
But I think we got a possible resolution. When I was talking with the probation department judge, to my understanding, they had already submitted the process for you to approve her to go to safety. But well, how did you explain that to me?
No, sir. She's just signed an amendment modification for safety.
For safety.
So she's agreeable going?
So didn't you tell me you were going to go to safety?
Yes, sir. Yeah.
Right. So
We just haven't submitted anything, though.
yes, so whatever is the thing to get her, well, look, I don't want to misspeak then. How about this? Whatever is the way to get her to safety, when I talk to the PO, he's good with her going to safety.
Is that what everybody wants?
That's
Because it's my call, not, yeah.
I'm agreeable with that, Judge. I don't
That's
have a problem with
what's
that.
in the best
We think
interest
that-
of all concerned. then
yeah.
I'm with it, if that's true. Okay, everybody's on the same page on this.
Right.
What do we do next then to get that accomplished?
I have the amendment ready for you to sign today.
Right, okay. What does this amendment say?
It's the safety modifications.
Which she will be kept in custody, then sent to substance abuse felony punishment facility for help.
That's correct. Yes, sir.
It was up to you to pass.
Yes, sir.
You gotta make good grades there.
No problem, sir.
You promised me you would follow all the terms and conditions of probation when we put you on probation, but here you are.
Yes, sir.
How about that?
Family things came up, but I'm taking full responsibility.
Good for you. Do y'all use forms on this when you do these?
It's a standard form. Yes, sir.
Is it? Well, it's no longer 2025. That's what I'm saying. If it's y'all's form, which you probably are using, that's a little outdated now. This.
Yes, sir. That was produced last year. I apologize.
Oh. Oh, she's been absconded?
Yes, sir.
Okay. For that long? Oh, okay. Well, we corrected it. I just signed it on this. This is a continuation modification of special conditions.
Yes, sir. She signed that last year. That's why it's
Okay,
dated.
so, but hold on. How long have you been in jail?
2 months and some days.
Okay. Who's on this one for the state?
I am, Judge.
How long was she absconding? Had she absconded?
Approximately,
2.
I believe it was 2 months, Your Honor.
I mean, you gotta pay for that. You're gonna have to pay for that. I mean, you can't just run off.
And I've been
You're on
in
my,
jail 2 months.
you're on my probation, not on
Yes,
your
sir.
probation.
Yes, sir.
But, here's the deal is, it's not personal, but what's good for one is good for the other. So people can say, Tasha Landry, I want the Tasha Landry rule. I want to be able to abscond when I decide to for 2 months. And then when I get back, then we just pick up where we left off. No, you've got to pay for it, for that. And it sets an example for everybody else, or what's good for one is good for all. What's fair is fair. So they are all reporting responsibly, who stay on probation. And if you fail, well, that's a condition of probation that you have to pay for. You have to pay a price for that. Well, you know that. And if I didn't, everybody would say, you let Ms. Landry go for 2 months and then you didn't hold her accountable. And there's a motion to revoke probation that's been filed. that doesn't even say anything about absconding. It's failing to never become intoxicated, failing to provide records and documents, failing to submit to alcohol and drug screening, failing to provide verification of entering and successfully complete anger management, being in arrears on your fees and all. Nothing about absconding, which is you were supposed to report regularly, which if you don't do that, I mean, number one, report is directed and obey all rules. That's the most important thing, because if you're not reporting, we're not supervising you. Thus, you're not on probation. You're on your own probation, which is the tail wagging the dog. That's not the way it happens. The probation office has to supervise you, and you have to report regularly. And if you abscond, that's a violation. But it's the most important thing. It's the most important thing of them all, really. Or else you're not on probation. It's a joke. It doesn't mean anything. And that's not going to happen on my wall tomorrow. Anyway. All right. So you're in jail. How long have you been in jail now?
2 months and
right.
probably 2 months and a week.
How's that working out?
I got a job. I'm not getting in any trouble.
No. I was. You don't enjoy being in custody.
No, sir.
Good. Okay. Whew.
Oh,
I
no.
thought you were heading toward a.
I didn't cry.
Hey, I
every
worked
night,
it out,
so
and I kind of enjoy
this.
being here.
No.
Okay, it's punishment. Good. It's like sticking your finger on a stove. It burns.
Yes, sir.
We don't want you embracing the stove.
Oh, no. No.
All right. What have you learned?
I've learned to follow the rules, all the rules.
And nothing but the rules. So
Nothing but
okay.
the rules.
Okay.
Yes, sir.
All right. So what do we do from now? From now on, Langston? What are we going to do next?
I'm hoping to get it at safe fee.
Okay. How long is that going to be, you think, until that works? And then she's there, was it 90 days or 6?
6 months.
6 months. Well, everybody says it helps them. That's what everybody says. But it's like everything else. If you don't do your part,
Yes, sir.
then it doesn't matter. People can wear themselves out helping you, but you have to do some heavy lifting, and you got to row the boat with them as
Yes,
well.
sir. No
It's your
problem.
boat. Okay. All right. Good. I want to review this so she doesn't get lost in the. I want to review it in 4 weeks, see where she is on things. Okay.
Okay.
To make sure that she's gone and she's just not languishing in jail. Okay.
Yes, sir.
Good luck. Yes, ma'am.
Okay. Let's go on the record in the matter. We'll recall the matters of City of Riverview versus James Carter, P1636 251418.
Your Honor, once again, Richard P. Toronto, P33828, hearing on both matters on behalf of my client. And Your Honor, the purpose of the arraignment, we waive for reading of both matters and ask for not to be entered for arraignment purposes.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment on all matters. And then counsel as to the trial.
As to pre-trial, Your Honor, the court will note these cases mirror each other and that the same charges are charged in each case. One from 2025, one from 2026. And my client will avail himself of the offers made by the prosecutor in that as to the matter in 25.1418, he will plead guilty to the amended charge of no valid driver's license in his possession. He will plead guilty to an expired plate, responsible to an expired plate and responsible to a no proof of insurance.
Yes, these cases mirror each other because your client, while out on pending one matter, failed to appear. Well, then he picked up another matter that was the same thing.
Two different cars, however, Your Honor, but the second charge,
I don't know that that's any better.
well, the second one is going to mirror the plea of the first. Plead to the amended charge of no valid operator's license. Plead responsible to the expired plate, as well as responsible with no proof of insurance. He understands all of those charges. He's ready for the court's examination. And if the original charges are dismissed upon a successful plea, we would appreciate that, Your Honor. Thank you.
All right, counsel, before I proceed, I'm going to ask your client, how'd you get here, sir?
My friend drove me.
What's your friend's name?
Steve Abercrombie.
Do you have car keys in your pockets?
No,
Not at all.
no, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
And as to the 2025 case, the amended charge of no operator's license on person, sir, how do you plead?
Guilty.
The amended charge of no proof of insurance, how do you plead? Responsible or not responsible?
Responsible.
As to the amended charge of expired plates, how do you plead?
Guilty. Responsible.
You've gone over, well, I'm sorry, let me go to the next one. As the 2026 matter, as the amended charge of no operator's license on person, how do you plead?
Guilty.
As the amended charge of expired plate, how do you plead? Responsible or not responsible?
Responsible.
And as to the amended charge of expired plate, how do you plead? Responsible or not responsible?
Responsible.
And you've gone over your advice of rights with your attorney as to both matters, correct?
Yes, Your Honor.
And you understand you'll be waiving some of those rights by entering into this plea.
Yes, sir.
Please. And you also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
All right. It appears though you're on probation, correct, sir?
Correct.
Out of two courts.
Yes.
33rd District Court, and then the 38th Circuit Court in Monroe County, correct?
Correct.
So you have two probations going on. So you do understand, sir, this will likely violate both probations.
Yes, Your Honor.
And knowing all that, do you want to continue with your plea?
Yes, Your Honor.
All right. And so, counsel?
Mr. Carter, on or about September 25, were you operating a motor vehicle in the city of Riverview? Yes. You had occasion to be stopped by the Riverview Police, is that correct? Yes. And first, upon the police officer asked you to produce a valid Michigan operator's license, were you able to do that? No. Is that because it was not valid on that day? Is that correct? Correct. The other infractions, this was someone else's car, but they did not have proper license plate tags or registration or insurance. Is that correct? Correct. I'm satisfied as to that charge.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea as to that matter. And as to the other one, counsel?
Mr. Carter, on or about February 16, 2026, were you operating a motor vehicle also in the city of Riverview? Yes. You got contact with the Riverview Police, correct? Correct. This was a different car when you were driving in 2025 that we just went over, wasn't it? Yes. Unfortunately, it had the same problems. There was no valid registration or not valid license plates. Is that correct? Yes. So you pled responsible to those. Is that correct? Correct. Now, as to the no valid officers in possession, did the police officer ask you to produce a valid Michigan operator's license? Yes. Were you able to do that for him or her? No. I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea. Any amended charges on that matter as well. Counsel, you're asking for immediate sentencing?
Your Honor, if the court is so disposed, you understand already that my client is in fact on probation. His status presently is revoked. Is that correct, sir? Correct. But we're hoping these things run concurrent with the Secretary of State, but I told him the Secretary of State certainly will take action on these matters. He's been advised, he's wearing a tether from the 38th Circuit Court. Is that correct, Monroe? Correct. And when does it come off, sir? Tomorrow. Why? Because I've had it on for 96. Were there any unsuccessful or positive drug or alcohol screens? No. All right. And you're aware that this court can now sentence you to any number of things: jail, probation, fines, costs, another tether. You understand all that, correct? Yes. Your Honor, we're hoping the court will restrict it to fines and costs, given time to pay those fines and costs. Obviously, he's not gonna be able to hide the facts. These are now convictions on his record. So he's going to meet with his probation department people as to each respective court, inform them of what happened. We would hope the court would not order any immediate jail time. For my client that you end up in jail, if not today, then if you in the future, if you violate, you're going to put yourself in jail more or less. So with that, Your Honor, we're ready for the court's examination. Did you post any valid bonds in either of these cases, sir?
No.
Right. He's in need time to pay any fines and costs as well, Your Honor. And he's working as self-employed with construction. He also helps his mother out with whose case?
My ex with my two daughters.
Oh, that mother. Okay, not your mother. Okay. Does your wife or the children's mother live with you?
Oh,
Is that yes or no?
yes.
Okay.
Sorry.
All right.
Wait, you all live together
Yes.
with the two children?
Yes.
How old are the children?
8 and 11.
So when you say you help their mother with the children, sir, I'm slightly confused because
Stuff like that.
excuse me,
Sorry.
because you are one of the parents. So as one of the parents that one would presume would have equal responsibility, how are you helping their mother out and not parenting your children? How does that work?
Does the mother of the children have any limitations or disabilities?
No.
But you equal partner, correct?
Correct.
Sorry if I misspoke that.
Well, no, it's an interesting choice of words that your client helps out with the children.
I asked that, Your Honor. I initially thought I put mother. I thought maybe he was helping his mother with his children. So I misspoke.
Sir. I'm not really sure. You didn't serve any jail time on either one of your convictions that you're on probation for right now?
Yes.
You did?
Yes. And it's been wrong.
And how much time did you serve, sir?
45 days.
And given the course of your life events, it appears based upon what your criminal history reads anyway, sir, I would think that you would likely not want to return to jail.
Correct.
So then why do you continue to violate the law?
Poor choices.
Well, yes, sir. Yes. That's why you have a revoked license from poor choices. Why, sir, do you continue to violate the law?
I have no idea.
Well, you do have an idea because you are taking the time to make the choice to drive a vehicle when you don't have a valid license because of your other bad choices that you've made, sir. So I don't know, and I don't have any idea. I don't work in this court. Why are you continuing to drive and violate the law?
Well, I had stopped driving since I've had this ticket, and I don't plan on driving until I get the license back.
Well, sir, here's where I have an issue because you had a pending matter of driving while license suspended or revoked from September in this court. And bless you. And then instead of showing up to court, you failed to appear and you had a warrant out for your arrest. And then you were arrested for the exact same thing. The exact same thing. Which tells me you have no regard for the law. None. It's like a big, flip of an appendage to the law is pretty much the way that it looks to this court anyway, sir. Why did you drive, sir? Why were you driving, sir, on September 29th of 25?
I can't remember what was going on when I got pulled over.
Okay, so it clearly wasn't anything significant that you would recall. It wasn't a significant life event. All right, what about on February 16th, sir, of 26?
I was picking stuff up from my sister's house that lives in Roseville. Some of my stuff that I had over there.
Why didn't you have her drive it or arrange for a ride, sir?
I try to, but
Then you don't go pick your stuff up. You don't go pick up your stuff. Just because you don't have a ride somewhere, sir, is not a legal reason for you to be able to drive. You don't have a valid license, sir, because of your life choices and the danger that you pose to the community because of all of your alcohol-related driving offenses. Based upon a review of Mr. Carter's driving status, based on a review of Mr. Carter's criminal history, the fact that Mr. Carter is currently on probation in 2 other matters in 2 other courts, the court does not find that there's reasonable grounds to depart from MCL 769.5. Sir, you have a felony child support as well, correct?
correct.
And so there's a child support order?
Not anymore.
Right, because you're all living together.
That was from my older 2 daughters.
Oh, okay.
That was already taken care of.
And you did not drive here today.
No,
All right, tell me why, sir, you have a warrant out for your, you have a warrant from Allen Park in 25th District Court, 2 of those. 3 of those. And then this one, which the court's recalled the warrant on that one.
Is that the one you told me you, as soon as you get done here, you're making a court date for the officer?
yes,
Why haven't you done that yet, sir?
because I haven't had the money to be able to for a bond or anything like that.
And so you do home improvement, sir?
Correct.
Okay, and you're self-employed?
Yes, Your Honor.
And do you have any other employees that work for you?
No.
No. And so how do you get to all of your job sites, sir?
Well, I'm a 1099 employee, so I work with other people. So I'm self-employed, but I work for somebody else.
Would that be Mr. Abercrombie?
And they come pick me up.
All right, so is that the friend that dropped you off?
Yes.
Okay. So, Counsel, in these circumstances, I'm,
Your Honor, may I suggest something?
what's that?
Well, if the court's contemplating jail or not jail,
I'm not contemplating jail. I'm just contemplating the number of days.
okay, would the court consider ordering this court's own tether in addition to a probationary status to give him a chance to prove that?
Well, unfortunately,
Right.
the tether doesn't tell the court if he's driving or not driving.
Well, correct, but he does have a substance abuse background. But any alternative you would be receptive to, Your Honor. He's got kids, he's got a job. He understands can't do any more driving. I used this court's own language and I said, aren't you tired of giving your money to different courts for all the suspendeds? He said, yes. So.
But yet he continues to drive. He continues to make a conscious choice to drive and disregard the law and disregard even his probation orders that he's not supposed to get in any other trouble. In 2 different courts, he's on probation.
We agree. And there may be jail time staring at him for those violations as well.
I would presume so. I would presume so. As to 251418, the court's going to order 30 days jail. As 26236, the court's going to order 30 days jail. These will run concurrent.
Yeah.
Just so you know, sir, you were looking at 180 days because I did not have to order these to be concurrent. And I could have sentenced you to up to 90 days for each one.
We understand that.
You need to get it together, sir. And stop just choosing to do what you want to do and not follow the law.
Your Honor, we have 1 day credit on each.
Your client wasn't arrested on the 25 matter.
No.
And I don't know that he was arrested on the 26 matter either.
You just said no. You strike that.
Right. So, the court's going to waive the fines and costs on 26236. And I'm going to also waive the fines and costs on 251418. Except, sir, you do have a $50 warrant fee that you have to pay. Is there a clearance fee also, Allie?
No.
Okay. So you owe $50, sir, on the warrant fee for 251418. All right, you're going out this door today, sir.
Your Honor, I have one other request. Court. He told me that some of the jobs that he's doing are incomplete, that he's expected to finish them. Could he have till Friday, Your Honor?
No. No, you can make whatever call and have whoever you work with, sir, do the best they can, but no.
Thank you, Your Honor.
Let's go on the record in the matter of the City of Riverview versus Lionel Martin Jr., 251715.
Your Honor, good afternoon. Richard Keith, Toronto, P33828. I appear in person today before the court. And my client, Mr. Martin, presently appears by Zoom. Your Honor, he told me that he got permission for to appear by Zoom because he's living in Indiana and presently going to school there.
Oh, that's right. That's right.
Football thing, and we went through all that.
That's right. Yep, so we need to make sure we have his new address.
I don't know if he intends to remain there, Your Honor, but.
Well, that's where he's living right now, so that's where we're gonna have to give the address and put that on there. But we don't even have an advice of rights form signed by him, so council will need you to do that on his behalf. We don't even have that.
Well, we are.
I'm sorry, I know that, but we still need to have an advice of rights form.
Did we do that last time?
Nope.
At the pre-trial?
Nope.
At the arraignment?
Nope.
Interesting. Yeah. Oh.
So, Mr. Martin, your name for the record, please.
Lionel Martin Jr.
Okay. And counsel?
Honor, after speaking to my client and the prosecutor, we're asking for a 3-week adjournment. That's the next time that I'm appearing in this court. The reason being, Your Honor, I brought today with me in court reviewed discovery of quite lengthy body cams and the like, witness statements, all for my client to review. I was going to give him that to take with him here, so he wants me to mail that to him. So I'm planning on doing that. But by the time it gets there, and ask for a 3-week adjournment on that basis.
It doesn't just, you can't just send him a link or send
I
him.
don't want to, Your Honor, because there's redactions. And I don't want to have to
Okay.
go back and forth and say what should have been there and what isn't.
So, Mr. Martin, it may be beneficial for you to be in person next time.
I don't think that would be beneficial to me. I don't,
And why is that?
because that's a lot of gas money that I don't have, and yeah, it's not like that.
So I can understand that gas is expensive, but I also understand, sir, that you have a criminal matter that this court has allowed you to appear via Zoom on thus far. When there are challenges for Zoom appearance, such as being able to review discovery with your attorney, being able to go over that discovery in a more efficient manner, then this court, sir, has the authority and the discretion to require an individual to appear in person.
Yeah, I feel like we could have did it over Zoom, but there's no problem with me waiting. And I mean, I don't have the gas money to get there right now. And
Sir, let me just say this. All right. I'm going to adjourn this for 3 weeks. So you have 3 weeks to come up with the gas money. Because since there's extensive video to review, and it is very difficult to review that video on Zoom when your attorney is in person.
so he's not going to mail it.
Excuse me?
So he's not going to mail the hard drive or flash drive.
Sir, that's not what I said. That isn't what I said. He's still going to mail the flash drive to you, sir. What I'm stating, sir, is that if there is a discrepancy or if there's something you want to speak about regarding the video, it is extremely difficult to do that when you are in another state on Zoom. Indiana's not that far away, sir. So it isn't as though I'm requesting you or requiring you to be present from the state of Texas.
Well, I'm having a financial hardship, and it's definitely inconvenient for me. And it's like I would be coming out there for no reason, to be honest. I mean, I understand I need to take care of this matter. Not saying this is not a reason, but I feel like Zoom is very much it's a valid reason to, I mean, I don't know. I can't really.
Sir, the court has allowed you to appear via Zoom thus far. It does not find that it's going to be productive for you to appear via Zoom for your next hearing. And I'm not going to continue to adjourn it because there's difficulty in reviewing the discovery. So I'm going to require that you are to be in person at your next hearing.
No, what if I can't make it, though?
Sir, if I recall correctly, you're working, correct?
Not anymore. Not anymore. I'm
Why
looking
not?
for a new job.
Why aren't you working anymore?
Because I lost my job. I'm gonna try to find something by the end of this week, and I can't really keep digging myself in the hole trying to. I don't think this is like a super serious matter, like murder or something. Like I feel like I can definitely
You
look
might
at
want
the
to stop
videos.
talking because that's not necessarily in your best interest to continue down that thought process. Okay. Because, sir, whether you think it's something that's not serious enough to warrant you to be in person is irrelevant. All right. So at this point, the court's going to order you. What I will do, though, sir, is I will give you 1 extra week. So, well, no, I can't because your attorney's not here in 1 extra week. So let's see here.
When you come back, sir, make sure you bring that flash drive with you.
I got a question about the plea deal that was offered to me.
No, don't talk about that now. Not on the record.
So we will see you here May 4th,
Maybe.
9:15 a.m. Sir, just so you know, it may be less expensive on the train or on the bus rather than paying for gas for a car. Just so you know, you have to check all of your options.
And what if I don't have the money by then? Because I'm telling you, it's like it's a financial hardship I'm dealing with, and I'm trying to get out of this hole.
Sir, do you have a driver's license?
Yes.
Sir, you have a valid driver's license. Okay, well, then you have Uber and Lyft, and you have DoorDash. There's ways that you can earn money, sir.
I wish
Legal,
it was
legitimate
that
ways
easy.
to earn money. What's that?
I wish it was that easy. It's not that easy.
Okay, well, there are many people that are in front of this court that are doing that for work, so I don't know the level of difficulty for that
Yeah, I can't,
or not.
I'm gonna try to find something though. I'm letting you know. I lost my
How long
job.
have you not been employed, sir?
Almost a week.
Turn your phone off.
Hmm?
I apologize.
I was speaking to somebody that disrupted the court proceeding. Turn your phone off. Don't look at it. Just turn it off.
Oh.
How long has it been since you've been employed, sir?
Since I've been unemployed,
Yes.
about a week.
Okay. All right. Well, I have confidence that you'll find a job. So submit 20 job applications per week, and that can help you. We'll see you back here in person on May 4th. Thank you. Have a good day. So Mr. Schultz, let's go off the record.
Your Honor, I do have Granite Tilla Valley in the waiting room. I can bring her in, and we do have Mr. Bogis's sister here in the courtroom. If you'd like to call that, that's up to you. I don't have any of the other 10 o'clocks ready yet.
You can bring in Granite Tilla Valley. Granite Tilla Valley versus Ronald Allen Bodges, 2600001. You want to come up here?
Yes.
I can't let you represent him, but I want to find out what's going on. Your name? Where's Granite at? 1 second. I'm gonna need the lawyer. Is somebody from Mr. Levine's office?
Mr. Levine's office is not in yet, sir. It's up to you. I'm so sorry. I just had. Okay.
That's okay. We're gonna have to wait until they come in. Okay. Thank you. Granite Tilla Valley versus Ronald Allen Bodges, 2600001. Come on up here, ma'am. Good morning, Mr. Landman. Your appearance.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Mr. Bodges' sister is shown up here. I'm not sure why. I'm gonna at least ask her to identify herself. Come on up to the podium.
Oh.
That's the podium there. Your name?
Michelle Bogus.
Where is he?
He is in the hospital. I went up to the desk and gave them the paperwork for the doctor, went through the emergency room. He is going along rehab. So all his rent is all paid up. There's a copy of that there as well. With her signing off on it and the receipts.
So, Mr. Landman, this is the one I was a little curious about. They started not only the termination action, but a non-payment action. If you'll bear with me, I think this is what happened is I stayed this case because this has to do with failure to comply with community rules. And he's charged with felonious assault. So I didn't per se stay it, but what I said is I don't think it's fair. He's got a felony pending, and I'm not going to have somebody in a civil case without a lawyer incriminate themselves. But in the meantime, your office did a non-payment rent case. I'm pretty sure, don't quote me, when I get rid of a case, I forget about it. But I'm pretty sure, unless your records will reveal differently, that I gave you guys a judgment with a writ date. And it sounds like Mr. Bodges has paid that now. You heard what his sister just said. I'm sorry, ma'am, your first name again? Michelle. So my inclination here is for us to double check on that. Jennifer, are you out there? Yeah, would you do me?
Your Honor, the property manager is present and raising her hand, so she may be able to give us some insight too.
Okay, thank you. Wait 1 second, Ms. Bryant. Jennifer, would you check on that? I'm pretty certain that I'm right on that. Ms. Bryant, you can unmute and tell me your name.
Suzanne Bryant for Granite Tilla Valley. Yes.
Is my recollection correct?
Right. He had a writ date of the 8th and he paid by the 8th. So it was all taken care of.
I don't think I can proceed on this termination action anyways. I mean, I don't think I can do that if it's solely on the basis of committing an assault on another resident. I don't feel comfortable with it. I got a guy here that's charged with a 4-year felony, and if he did it, I don't have any remorse for him, but I still have something to do here and that is to protect people's rights, and I can't imagine me forcing somebody to go through with the hearing. So I can do one of two things for you. I can adjourn this again. But I'm not going to set a hearing date until there's a resolution of the felonious assault case in circuit court. So I'm inquiring whether or not you may be willing to dismiss this and refile when that issue is resolved. Ms. Bryant, you had your hand up again. I can't change my mind on this. I want you to understand. I won't. But go ahead. What do you want to say?
Your Honor, if I may, before Ms. Bryant, firstly, which hospital is he in right now?
He's in the Heritage Hospital on Telegraph Road. When I came in, I went to the desk and they have all the paperwork that's notarized, signed by the doctors, all the receipts.
Who has it?
Pardon me?
Did you go to Heritage or did you bring the paperwork here?
I took him to Heritage, then I came here.
I know. Where's the paperwork?
Yeah,
Your
it's
Honor, it should be in your file. We did bring down a copy.
Yeah,
Oh,
I brought them.
so it just said he's admitted on April 12th and will remain inpatient until medically cleared.
Yes.
So did you want to say something else?
Your Honor, I do need to make a record on this.
And you're going to say
as the court is aware, the standard in this particular
I know.
case is a civil standard, which is
I
weight
know.
of the evidence.
I know.
The problem that the concern that I have is I have a history, not with this particular individual, but in a different court, in a different case with a similar situation, that being a tenant that was charged with an assaultive crime. There was a delay of approximately 3 years from the date of the offense until the termination case was actually heard.
The same reason that I'm mentioning, though, right?
But under no circumstances is my client going to dismiss the case and then turn around and have to file a new 30-day notice whenever these other proceedings are concluded. My recollection is that in this case there may also be a competency situation, and the last thing I want to see is this case delayed while we're waiting for the defendant to be competent to stand trial in the criminal case.
What do you want me to do, Mr. Landman? Tell me what you want me to do. I can't proceed.
There's I see two possibilities, Your Honor. Well, three possibilities. What we would prefer, obviously, is for a trial date to be scheduled. That not being an option, then there's two ways to go. We could do a conditional dismissal with the tenant agreeing to move out by a date certain. We're not able to do that today, obviously, because he's not here. The other option is to, again, adjourn and get a new date. And if the tenant is willing to vacate, we can get a conditional dismissal in before that date.
It doesn't, well, he's got to agree to a conditional dismissal,
He would,
right?
yes, that's correct. And obviously, you can't do it today because he's not here.
There is no way I can go ahead and proceed with the trial on this. I just am not comfortable with that. I'm not even sure I don't believe now I could be wrong. He just paid the money on a non-payment case. That signifies an intent that he has no intention of leaving.
Well, he's also required by statute to keep his rent current while the termination case is pending. And that's MCLA 600.5779.
I get all that, but that tells me he doesn't want to leave. Right? I mean, if he wanted to leave, he would have not paid his rent and just left, right? So I'm pretty confident when he comes back here next time, he's going to tell us that he doesn't want to leave. I am not going forward with a trial on this without a resolution of the Wayne County Circuit Court action first. I'm just not comfortable with it. There's no way I'm doing that. That's not fair for me to do that. He might be not the best person in the country, but you know what? He has rights and I'm not going to violate them. So what am I supposed to do? Keep a landlord-tenant action open, like you say, for 8 months? I mean, I guess the Supreme Court is going to come down on me thinking I'm fooling around down here, but that isn't the case. And I can't enter a stay of this and have the time guidelines stop running, or I would. So I'm not quite sure what the answer is, but
I think he has a trial date. Currently, there's a trial date, I believe, in July, but I don't know what the competency ruling of the decision is going to be between now and then.
and that's probably going to get delayed because the competency exam staying everything else essentially. They're not pre-trying it. They're waiting for the report. I'll adjourn this 2 weeks to April the 27th. Jennifer, is that right?
That is correct, Your Honor.
At what time? 8:30?
No, let's do 9:30, please.
Okay. 9:30. I'm just asking you guys to put yourselves in my position here. I would waive any filing fee. Obviously, if you agree to dismiss this, I can't do anything about the 30-day notice, although maybe I can figure out something. At any rate, you guys come back and I'll see you on April 27th on that one, okay? And then you can
And Your
tell
Honor,
Mr.
in the
Bodges-
meantime, if the court can, I don't know if the court has any information that's available to the court and obviously not available to me with respect to the status of the competency evaluation. I'm assuming that this gentleman has counsel in the criminal case, perhaps court appointed, but I would also expect that that case is at least moving forward to some degree, and that a competency evaluation would have taken place or would be scheduled rather than the case just sitting fallow.
No, I think the problem with the competency exams, I don't think you do a lot of criminal. The problem with those is that they get scheduled, especially for somebody who's not in custody, a couple months down the road. And that's always the difficulty there. Now, he told me, I think it was just one of the last couple of times that the competency exam had been ordered. So maybe there was a delay in doing that. And
Your Honor, Ms. Bryant has contributed and indicates that there is a competency exam scheduled for May 23rd.
Right.
So maybe April 27th is not a great date to put this out. Maybe we put this out until after the competency exam.
Competency exam, by the time they get the report, it's going to be June the 10th. I want to think about this. I'm going to still keep it on for April 27th. You'll have other ones that day. I might dismiss this on my own. I don't know how I'm going to handle it. I'll think it through. Good luck. I mean, I can't do that really, but maybe I can come up with something that's creative. Have a good day. That's what I'm doing. Thank you. Preston Point versus Chanel Hines, 2601467. Good morning, ma'am. Your name, ma'am?
Chanel Hines.
Okay, you got to keep your voice up for me, nice and loud. Did you listen to and understand the rights on the video?
Yes, I did.
You wish to speak to a lawyer or apply for funding?
No, sir. No, Your
Mr.
Honor.
Drozak, your appearance?
Good morning, Your Honor. Mike DeRosak appearing on behalf of the plaintiff, Preston Point.
How much does she owe in total?
In total, all in, we have $2,686.94.
Can you pay that, ma'am?
No, that's not correct. It's 12/14/25. As of March 26th with the fees. And then for April, it is with the fees 508, and it should make it like 1722.25.
Wait a minute. He's indicating a rental rate on his complaint of $1,450.
Yes, but there was a subsidy for that, so the amount was only
they don't
$383.
have
I'm
to
looking at
include
the
the sub-
ledger. I'm sorry. Say
They
that
don't
again,
have to-
Chairman.
They don't have to include the subsidy in their amount if the.
Okay, I'm basing it off of what I received in my door. They're going to
Hang
still
on,
receive.
slow down 1 second. 1 second.
Yes,
What
sir.
was the total amount owed as of March the 26th, you said?
On this ledger I received in my door with the court, it was $1,214.25.
So, but they're entitled now to the 1,450, right? Plus a late fee for April, right?
This was just through March, and then April would be $383 is my portion, plus their $125 late fee. So
Have they
that would
been
be
paid?
another.
Have you guys received I don't know who the subsidy's coming from. Have you received any payment from them?
We have not received a payment, Your Honor, since March 9, according to the ledger.
So on my math, you got 2664.25 plus a late fee. I don't know. I think they shortchanged themselves.
No, the total amount should be, Your Honor, because it was the note in my door was for the $965.25, which was correct with their late fees. Then they added $250 in legal fees on the 26th of March. And
Well,
the
what are your late fees?
$50 a month, Your Honor.
The late fee, they're charging $50 and $75. And so $125 a month in late fees each month, $249 in legal fees. My rent is $383 for the month of April.
But your rent isn't $383 if it's $1,450 and the rest is being paid by somebody else.
It's being paid by the veterans program, the veteran housing program.
All right, let's
So
slow
they
down.
pay the
Let's
HAP
slow
program
down
pays.
here. Let's slow
Yes,
down
sir.
here. Let's slow down here. You know, I'm not going to give you $125 a month in late fees. I'm going to give you $75 in late fees at maximum. The complaint says the monthly late fee is $50.
That's what I have written down for my review of the lease. I don't know that they actually charge this 125 that Ms. Himes is stating, but I'm happy to
It is charged.
to
It's in the
review to
ledger
make
that
sure
the-
that it's not in there. Judge, I know we can't do 125 in your court.
So
it's in the ledger. I'm looking
Wait a
at the
minute,
ledger,
ma'am.
Your Honor.
Wait,
that I guess the
please
bailiff put on the
stop.
door.
You're really interrupting now. Please.
I
I'm trying to get to the bottom of this, and you want to keep insisting that your portion of the rent is only $386 or whatever you're telling me. That's great. But they have the right to charge any balance on this account. So if you owe $1,214.25 and the rent, if it's true, is $1,450 per month, whether it's coming from you or the veterans program, it's $2,664.25 plus a late fee of $50, and that's $2714.25 plus any cost. So I don't know why you're saying you only owe $1,500 or thereabouts. They're entitled to charge that if they haven't received it from the veterans program. It's incumbent upon you to call them up and say, listen, they're going to throw me out of here if the judge doesn't, if you don't make this payment for me. So he's an officer in the court. He's not going to lie to me. If he did, he'd have big problems. Plus, he's never lied to me before, and I know he wouldn't lie to me now. And he's not going to tell me that they've not received the payment from the veterans program if they've received the payment from the veterans program. Now, I want to work with you. I want to work with you and help you make this payment if I can. I certainly want to do that for you, ma'am. But we got to get past what is owed first. And I'm not quite clear why you're telling me it's only $1,500 or something, because they don't have to take into account.
Yes, sir.
Well, tell me now. I've explained to you, but
Okay,
I
yes,
don't want to
sir.
argue about this either.
No, I'm not. I promise you I'm not, Your Honor. I'm at work right now at the VA, and I'm just trying to explain what I received in my door. I've never received a ledger before. I'm holding the whole packet that came in the door with a ledger that I've never seen before attached. And at the bottom of this ledger that they printed out, that I guess the bailiff or whomever put into my door, says March 26th, the total fees due is $1,214.25 through the end of March.
Yeah, but your April rent's due now.
I understand that, but what I was trying to explain to you, Your Honor, was that they receive a check from the HAP for the subsidy. It says Section 8 HUD rent as a HUD VASH program as a vet. Okay, they may not have received that payment yet, Your Honor, of $1,067. That could be why they're factoring in it being $14.50. That's what I was trying to explain. But at the end of this ledger, it's saying I owe $1214.25. Then for the month of April, my portion of that subsidy, Your Honor, will be $383 plus their $50 late
I'm
fee
trying
plus
to
their
tell you,
additional
I'm not just
$75 late.
including your portion. That's not fair to them.
They're going to receive their payment from that program. They have in the past, and they will continue to do so. And it comes after my portion is paid. That's what I was trying to explain to you, Your Honor. So that's why I was saying they were going to still receive that 1067. I understand you're factoring it in, but
Your Honor, I expect that we will receive the 1067. Of course, I have no idea when that will be. I have no problem extending the writ date a bit if that would give Ms. Himes some comfort. That would give additional time for
Well,
that
that's what I'm trying to
subsidy be
do,
made.
but I don't want to keep going through this. I mean, I don't understand why you're even at only 2664, whatever you told me, 2686.94. You should be more than that. But
No,
I don't know. I'm good to give you the 2686.94 because I'm convinced that you're at least entitled to that. And if I do the math on this, including your filing service and statutory attorney fees, you're going to be closer to $3,000. But I'll give you the 2686.94.
I don't owe that.
Why are you shaking your head, ma'am? Why are you doing that? I don't want to argue with you.
No, I'm not. My portion total, Your Honor, as of today, Your Honor, with April's rent and the late fees would have been $17.42. And I understand you're factoring in at $14.50, but they're going to get the 1067 for the month of March and the 1067 for the month of April from that agency. So based on this ledger, I have this 1214.25 through the end of March 26. I was just going to ask for an extension for my subsidy portion for the month of April with the late fees, which would have been 508. And I was going to ask.
Hang on. Am I missing something? You are free to tell me, Judge, I see your point and I'm wrong.
No, I don't think you're missing anything, Your Honor. And like I said, I'm happy to extend to the end of the month if that'll give Ms. Himes comfort to make her.
He wants to keep arguing with me, and I have no other way to do this. I'm sorry. I can extend this long enough for you to get on the phone and call him and say, send him the money. And I can extend it, ma'am. You're going to keep interrupting me now today. I just can tell.
No, sir.
I love it when people interrupt
They're not going
me.
to send it until I send my portion. They're not going to pay it. I can't call them because they're not going to pay that portion, Your Honor, until I pay my portion. That's why I was trying to seek clarification on my portion. That's all, Your Honor. I'm not trying to argue. I just was trying to elaborate on the ledger. I'm not arguing
I'm
with
going
you,
to give
sir.
him a
I would
judgment
never do
amount of
that.
2684.94, 2686.94. I'm convinced that between you and the agency, that is at least, I know you're shaking your head, but that's the amount that's at least owed. Now, I can extend the writ date. He's entitled to one on the 23rd, but I'll be happy to help you out here if you just tell me what you can afford to pay and when.
Can you please give me a breakdown of this 2686.84?
Go ahead, Mr. Jarozik. 2686.94, I think you told me, right?
Correct. That's the total. And what I did, Your Honor, and perhaps what I've done is when I took out some of those $75 late fees that I saw on the ledger. So what I show is rent retained possession of $2,290.25. 3 months of late fees at $50 each of $150. I have court costs of $246.69, which gets me to the total of $2,686.94, if my math is correct.
Okay,
And is that paying me through April, Your Honor?
Yeah, that would take care of everything through the end of April.
That's correct.
And 2290, can you break that down? How you got 2290? Is that 1450 times 2? Is what I'm just asking.
That one's a little more difficult because the last zero balance I see is October of 2025. So there's been payments made here and there, so it's not a flat 2 months. We'd have to you go back penny by penny for many, many months to get to the last zero balance to move forward to figure out
So
exactly.
I'll
what
tell
that
you how
amount
I'm
to.
calculating it, man. You told me that as of March the 26th, and you seem to adopt this, that the total amount that you owed according to the ledger was 1214.25. Whether you agree with it, like it, don't like it, I'm adding in the 1450 for the month, starting April 1, which is 20, which brings the total to 2664.25 plus a $50 late fee, which would take it to 2714.25, and that doesn't even include your court costs or statutory attorney fee, which he just spelled out is another $396.69. So at the very minimum, you're getting a break here. Now, I'm going to order that, and I'm not going to argue with you. I'll invite you to tell me when you can pay. You're shaking your head. I hate when people shake their head at me. I just hate that.
Because
you want to get off here and tell everybody I'm the worst judge in the country, feel free.
No,
I
it's
hate
not that.
That's disrespectful, and I'm
I
not going to argue
apologize.
with you anymore. I'm going to
I
try to help
apologize. I
you.
wasn't arguing. I was apologizing, Your Honor. I said I
You're shaking your
apologize.
head at me. You've been shaking your head.
Because they're going to pay them 1067 for each month they have in the past.
I mean, I get it.
And
I've already gone through
and
this
he's
with you
saying that
3
there were
times.
balances in October,
Ma'am,
but I paid the 900
I'm not
like when I
reconsidering. I'm not reconsidering. I'm asking you to tell me when you can pay this so I can help you. If you persist in arguing with me about who's going to pay who, when, and how much, I'm just giving you April 23rd. Period.
I won't okay, Your Honor. Would that include them making their payment of the 1067 through the agency for March and April through
Yes, that
April
includes
30th?
this payment. Yes.
Would that be, Your Honor, would that be subtracting from the amount that you're saying that I owe? Because I only owe what I tried to explain.
Yes. It would be subtracted. Absolutely. I'm not trying to stick you with this and then have them say they still got to pay them the 100,000 and whatever amount of dollars. This is all included. They're entitled to a judgment on the rent that's owed, whether as to what has not been paid. And that's what I'm trying to tell you nicely. And you want to just keep arguing with me. Can you pay
I'm
all
trying to
of this?
understand. I was trying to understand. What is the exact amount that you're saying, sir?
Can you pay all of this money, including the subsidy money, which you will be credited for, by April the 23rd or April the 30th? Can you
April
do that?
the 30th, but what is the full amount, Your Honor, that you're referencing? The 2290, Your Honor, 25?
No, 2686.94.
I have 1214 and 25 cents that was at the end of the ledger. Can I pay that tomorrow when I'm off? I currently have 1214.25 in a money order, which was through the end of this ledger. Can I make that payment at the office tomorrow, please? And then subtract that from this 2686.96 that you're that is being
I'll tell you
stated
what
that
I'm
I
going
owe.
to do. Defendant, defendant to pay 1214.25 by April the 14th. And if she pays that amount, the writ date is extended until the 30th of April. Okay, so you pay that 1214.25. They should be able to then pay the subsidy kick in. And all of that's added in, and the total amount that's paid between you and the Veterans Program will be $2686.94.
Very good, Your
Okay.
Honor. I'll do
Yes,
that.
sir. Yes, sir.
All right. Thank you very much. You'll submit that order, Mr. DeRozak?
Yep, we'll get that prepared and
I'll
submitted
receive
right away,
something
Your
in the
Honor.
mail.
You'll receive that. You should have it from me signed in the next day or so, ma'am.
Thank you, Your Honor.
Good luck to you. Thank you. Thank you, Mr. DeRozak.
Thank you, Your Honor. Good seeing you again.
Too. Gary Allen Hayner, 23B, 14335A and B. Yeah. All right. So what is he going to do?
Judge, hopefully guilty to failure to comply. He was sentenced on this case back in 2023, Judge. Mr. Hanner was having some personal problems about some financial issues. His main issue was financial. His children's mother had suffered an injury at work. And
All right, let me just take the plea first and then we'll go from there. Okay, and you can allocute then, okay? So, sir, you have a disorderly person, public intox. You have a resist and obstruct an officer. I sentenced you on these back on August the 2nd of 23. You were then supposed to be here for a show cause because you failed to enroll in on-site testing. And you were supposed to be there and enroll on August 4th. We set a show cause. You didn't show up for that on August 22nd. So that is the charge. Failure to enroll in biweekly chemical testing is ordered on August 4th of 23. Do you understand the charge?
Yes, sir.
If you plead guilty, excuse me, or if you are found guilty, I do want you to understand this is a non-technical violation here since you did not show up. You've absconded for more than 90 days. So you could get, or for more than 60 days, I should say, I apologize. And you could have your probation revoked and you could get 90 days on each of these charges. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand and advice of rights being here today?
Yes, I did. I don't know that it's not. Did you sign a double sheet certs that believes that I mentioned this?
Mr. Hayner, have you now had a chance to review the advice of rights? Did you sign it?
Yes.
Did you understand it?
Yes.
Did you go over it with your lawyer?
Yes.
If you plead guilty here, you're going to be giving up all these rights and we're not going to have a hearing of any kind. Do you understand that? All right. And you understand you could, since you've absconded, this would be a first technical violation. But since you absconded, you could get 90 days on each of these files. Do you understand that?
Yes, sir.
All right. You still wish to plead guilty
Yes.
to the charge that you failed to enroll in biweekly testing by August 4th of 23. How do you plead?
Guilty.
Did you fail to enroll in biweekly testing by that date?
Yes, sir.
And you were told by the probation officer to enroll, true?
Yes, sir.
And you failed to do so? You just absconded then, right? This was the day after the sentence and you decided you weren't going to do anything?
Yeah,
I just want to know, is that true?
correct. I was captured and I didn't have a license. I didn't have anybody, like any family support. So I was kind of like flying by the seat of my pants. So maybe, yeah, like I didn't have a way to do.
Anybody force you to plead guilty?
No, sir.
All right, I'm going to accept your pleas. Now, what would you like to say, Mr. Gabe?
Good, just that, like I mentioned earlier, it was an issue of finances at the beginning. He did not have a valid license. He didn't have a stable place to stay because he couldn't afford to pay rent. Majority of his money was to help the mother of his children, but it suffered a back injury at work. So in addition to having to pay her child support, he was also picking up some of the additional expenses for the household. And because he does share two children with her, 15 and 16, I believe. Is that correct? Yes. And so at the time, not only was he unable to come and go, even if he had a job, but any money that he did have went to trying to help keep that household in place and keep them at least somewhat solvent at this point, because there was no money coming in on either side. Judge, he did walk in on his own. So I'd like the court to consider that. And he is able to pay the entire amount of the balance due today, Judge. He is also, since then, he's had no run-ins with law enforcement whatsoever. He's trying to resolve all of his outstanding issues, Judge. He's full-time employed at B&D Gold-Headed Products in Wayne City. He's been employed since 2018 with just some gaps in between that, and what that wasn't steady employment. One of the gaps would have been right around the time that he caught this case as well, Judge. But now he's back to full-time employment. He does work the night shift, so he's able to clear as far as any balances due, and he'd have the court to take that into consideration, Judge.
Where are you working now?
Work at B&D Drug Roller, B&D Gold-Headed Products. It's off Van Born and Wayne, Van Born Road in Wayne. In Wayne City. Yeah, just outside right.
Silence.
He lives with Probation, Your Honor.
Anything at all?
I was just reviewing the file, Your Honor. We didn't get noticeable warrant recall. It looks like Miss Tessino, who was supervising him at the time, met with him, got him instructed, and then essentially absconded right after that. The only thing I would have to go back in my office and check on is see, not sure if it was mentioned, if he did any of his court work program days. He was scheduled, but I would have to look at those sign-in sheets in my office, Your Honor. But other than that, again, there is no verification of treatment, 12-step meetings. The test that the violation was issued for was his initial test with onsite. So it looks like from the beginning he absconded, Your Honor.
Right.
Because I don't believe, in my discussions with Mr. Hayner, I don't believe that he's done any of these.
No, it was, I sentenced him on August the 2nd, and he didn't enroll by the 4th. And that's when he just left. He just decided, for whatever reason, I don't care if it's didn't have a ride. You just can't do this.
And turned myself in other cases I was in, did some time around that, right around this time too, by that, I was in Wayne County. And I'm probation for them from the district court since, for 2 years now.
Out of the Third Circuit Court, you mean?
Yes, yeah.
Right.
Because
you had a felony.
For the child support.
Yeah, and I took care, I had stuff in row, I went and took care of, turned myself in, and I had a bunch of other deals I was taking care of too, and this, I don't know, it gets a lot on my plate. Doing the best I can, I'm trying to take care of it now. I'm doing the best I have done.
I do have a scrutiny, Judge, if you can see it.
Please. I mean, I see why I did what I did.
A lot of the station during events, so I'm trying not to go down these roads anymore.
How much is owed on? You tell me.
276.
983 and 276. So he has $1,214 on, right?
You can pay that, I can pay 900 today. That's when we make the phone call, I want you guys to probably get to all 12. Was in that impression, it was like 880.
The file said 840 at the time.
You just can't do this. Probation's revoked. You're on the disorderly person charge. You're to pay costs of 900 and serve 90 days, credit 1 for 89. If you pay 900, I'll suspend 59 of the 89. You'll only have to serve 30. On the R&O charge, same thing. Probation's revoked. You're to pay costs of 200 and serve 90 days, credit 1 for 89. If you pay 200, I'll suspend 59 of the 89. You'll have to only serves 30. So you have to give them $1,100. You have 21 days to appeal. Here's the lady. 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. They'll let you make a call. Just can't. It's good luck. Thank you.
We will go on the record in the matters 15 CT 50, 15 CM 172, 16 FO 48, 17 TR 353, 19 CM 207, 20 CF 256, 20 TR 563, 564, 21 CF 56, 22 CT 37, 23 CF 171, 24 CT 07. State of Wisconsin versus Richard Connors. Mr. Connors appears in person without counsel in custody on those cases because those are fail to pay commitment warrants, and he was picked up on the fail to pay commitment warrants. We also have, well, and I think it's 25 CM 180 is also done. I have that there's an offer for that one. Oh, is that one still open? There are just way too many of Richard Connors cases. And I need to pull up that new one. Okay, there we go. Oh, Mr. Connors, we have too many cases.
That's what I say too.
Well, then stop.
I
All
didn't
right,
even-
okay, that one's
Oh.
still open. 25 CM 180 and 26 CT 16 are still open. State of Wisconsin versus Richard Connors. The state appears through Assistant District Attorney Jose Vila. We have Amber Sherwood making a special appearance for Joel Feliski, who is assigned these cases but unable to appear here today. And we have Richard Connors in custody in Burnett County Jail by video. All right, in 26 CT 16, has he, Mr. Feliski, or yourself gone over the criminal complaint with Mr. Connors?
Yes, Attorney Feliski has. Mr. Connors understands the maximum possible penalties, and we waive a formal reading at this time and enter not guilty pleas.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. And there is no update, or there's been an offer?
There's been an offer on 25 CM 180 for AODA assessment.
Oh, that was from a long time ago. That was way from December or November or something.
Attorney Feliski is attempting or going to be speaking with Mr. Vila about getting a global offer to resolve both that and 26 CT 16.
Global offer, Mr. Vila.
This is an OAR. I don't think he can even get his license anymore at this point. So it's probably gonna end up being for a time serve, because I think he was booked in at the end of March. So AODA for DC for costs, and then the OAR will be time served.
All right, so that's the offer for those two cases. And so Mr. Feliski is going to talk to you. And so you're saying plead to the charge of the OAR time served for
Yes, Your
whatever
Honor.
days, and AODA assessment and costs for the disorderly?
Correct, Your Honor.
Okay, so that's the offer on those two matters, Mr. Connors. Okay, do you understand that offer?
Yeah, I understand that offer, Your Honor.
All right, Mr. Feliski will be in contact with you concerning that offer, and if you wish to accept it, I do need to set a status date.
I would accept that, Your Honor.
Okay, but you have to, your attorney has to
They have to go
look
through
at
the
the offer and he
motions.
has to talk to you about it first. I mean, if
Okay.
you want, I can see if he's gonna be here this week and we can have another status. Otherwise, I have May 11th. But then we're gonna have to discuss the fail to pay warrant and all of that jazz,
I have another.
because you are significantly, you've made like, okay, you owe over $13,000, like $13,500 back to 2015. From 2015 until racking all of that up with all of the new cases. Plus then if these resolve and have additional costs and fees, you've only made a payment of like a total of $570 payment since 2015 until today on 13,000 and some odd dollars that you owe. That's not showing me that you have a good faith effort to try and pay off your fines and fees.
Your Honor.
And you, yeah, what's up?
I hate to interrupt you, but I had just checked, like, well, I've been in here for 2 weeks, so it was like 3 weeks ago, I had checked. Went on wisconsin.org, fines and payment plan, fines, to make sure that I had nothing that I owed. There was
Oh,
nothing
then you
on,
checked wrong. You checked wrong.
but then they put out half the stuff went back, it was on taxes, and then half the stuff went back to you guys. And
You
they
wanna
just
know
put a-
why?
They put a warrant out.
You wanna know
for-
why?
For me. Well, I know, but
Wanna
they
know
didn't
why?
give me no warrant, they didn't give me
Stop
no warrant,
talking.
they just put a warrant
Stop
out.
talking. Stop talking. You want to know why it came back to us? It went to state debt collection because we tried to collect for a decade and you didn't pay. So it went to state debt collection. And then state debt said, oh, there's nothing I can do because he's not filing taxes. So I can't get the taxes. So I can't get it. And he's not going to pay. So sorry, state debt is, we're not wasting our time and effort on it. Burnett, you get it back. So Burnett, you're the ones who have to collect this money. You owe it. It's a lot of money. And you've only made a total of over 500, almost less, it was less than $600 since 2015. So that's what we have to talk about. And we're going to have to figure out a plan for that. And we also need to figure out a plan for your other court cases, which again will add on significant costs. So
Attorney Felisky is here in the afternoon on Wednesday and on Friday, Your Honor.
let me check. Okay. Afternoon on Wednesday?
Yeah, looks like he is here from actually about 10:45 until the end of the day, Your Honor.
Oh, he shouldn't be here until the end of the day because I have a half day probate case. If he's planning on sitting and watching or contributing, that would be great too, because that's going to be.
He has a plea and
lot.
sentence hearing on the 15th.
At 10:45.
Yes, Your Honor.
Okay. What I am going to do is I'm going to set the cases for 10:45 on April 15th. Wait, let me double check. No, he's going to be here in the afternoon on Friday. I'm actually going to do it Friday because I'm not going to double book and triple book to fit this in when I am booked solid on Wednesday. So I'm going to do it at 1:30 on Friday. 1:30 on Friday. We're going to have a status with Mr. Felisky. You're going to talk to him about the offer, etc. So we are adjourned as to 25 CM 180 and 26 CT 16, but we are still on the record for those other cases. So let me know, Mr.
Is there any way to do like,
Mr.
they said that I
Connors.
could do $500 payment? That's what I was trying to come up with. That's why, well, I knew I had a warrant out, but they said if I could come up with $500, put towards that fine, start a $500 payment plan, that they would accept that.
Well, by
Anyway.
they, you're talking about me because I'm only the one that gives the authority to do any of it. So you're right, I did.
I called the clerk of courts trying to get this all straightened out because, like I said, I was checking up on my fines and making sure I didn't have fines to pay out too, besides the taxes, because I knew I was pretty much screwed.
Yeah, the taxes, I don't deal with the taxes. That's a county issue. The county's going to come after you for those, for your real estate taxes, those kinds of things. What you owe me are court costs and fees.
Yeah, I know, but they just came out
Restitution
with that.
and
There was nothing on there.
surcharges.
There was nothing on there, and that's what I'm saying. And all of a sudden, I got a deal in the mail saying.
Oh,
that- I was just- I was
Mr.
trying to
Connors.
get it straightened out,
Mr.
but
Connors, I was not born yesterday. I know you know the things. I know you know the things. It's been since 2015. I know you know you can, because you just said, I picked up at the phone, I called the clerk and I talked to him all about it. I know you know how to do it. I know you know how to use words to try and talk and to do the things. I know that. So no, I don't believe that you did not know that you owed a lot of money to Burnett County, minus the taxes that you owe. So I will accept, aside from your criminal cases, because those are completely separate. So if you have bail requested on those, that's separate from what I'm telling you here today. Because I do find you in contempt for your failure to make any payments, only making around $570 payment from 2015 until present. And you owe $13,500 and some odd change. So with regards to all of the other cases, not the 25 CM 180, not the 26 CT 16 that may have bail associated with it, I will accept a $500 down payment, $500 a month thereafter. However, the additional payments won't start until you can actually bail yourself out or you're no longer in custody. But to be able to get out of custody on my fail to pay warrant, it's $500. Or because you haven't made those payments, and I don't believe the excuses, you know how to figure out if you owe money and you have failed to make payments and do those things. I'm going to sentence you to 30 days in jail if you fail to make payments. So $500 down, $500 a month. If you fail to even make one monthly payment, and a warrant will be issued again, and you will sit 30 days and we'll start all over because it's up to 6 months per case, 6 months per case for failing to pay. Okay. So that's what you need to do. All right. And we'll see you on Friday, 1:30 with Mr. Felisky.
All right.
Thank you. We're adjourned.
Thank you.
All right, Zebedee Shaddis. And who are you, ma'am?
I am Zebedee's sister and his social security representative payee.
Okay.
He doesn't have any money beyond that, and I'm the
Well,
person
I get to
responsible
make
for
that
paying.
decision, so that's my choice, and my discretion, my decision. And I will only allow you to sit there because you are his PR or payee. But otherwise, only attorneys are allowed beyond, end up parties beyond that. We will go on the record in the matter 13 CF 132, State of Wisconsin versus Zebedee Shaddis. The state appears through Department of Correction agent Gretchen Annabis. We have Mr. Shaddis appearing in person without counsel. His sister makes an appearance with him. She is the payee for his, I believe, Social Security. What is your name?
Naomi.
Naomi Shaddis. Naomi Shaddis, and is it Naomi Naomi? Excellent. Okay. All right. Ms. Annabis, please update the court as to where we are with Mr. Shaddis and what the DOC is requesting.
Mr. Shaddis is currently unemployed. He has his sister for assistance. He needs family for assistance on day-to-day activity. From the knowledge of that was received from Minnesota, he does monthly visits over the phone. He is compliant. However, in regards to his restitution that he owes, which is $481,308.72, and his release in 2023, there has been no payment made. From his budget worksheet, I do see that there leaves no room. However, to make the victims feel whole, the department is requesting $254 a month.
Right. 481,000 and change. Okay. All right. I'm trying to find restitution. I cannot even find a restitution. Restitution order, go from 2014. We do have victims here. I know we're in victims' rights compliance. And I don't have, this is such an old case. Did insurance not cover anything?
I do have a victim for like this.
The victim can speak if they know about Paul and Christine Stavney or Stavney.
I'm Christine.
Christine, and I know your husband passed away. I recall that. That's why I was hesitating. But it says $429,273.50 is payable to you. Did insurance not cover the house?
Insurance covered, I don't remember what, but yes, we did receive insurance money. But I don't.
But so you received insurance money, but was that the full value of your house?
I don't believe so.
Because back in 2014, I mean, unless you were in a mansion, to me, it seems like the insurance company paid out and that you should not have been ordered. It should not have been $429,000. Okay, restitution breakdown. I'm going to the transcript. Well, it looks like insurance was gone really thoroughly over. All right, well, I can't find that Judge Cutts, he went thoroughly over insurance in all aspects because there were multiple insurances and then you needed to go to high risk insurance and that there were some medical and other things that insurance didn't cover. Because you had AAA as well as other things. So it appears in the sentencing hearing, which also had a restitution hearing attached, insurance was gone thoroughly over. Ooh, 8,000 comic books. They have 8,000 comic books. Gotta be a lot. Huh. All right, I can have a brief statement. Who was providing this? Okay. So KS.
Yep, okay, sure. Thank you. Anytime?
Yes.
Okay. Thank you for your time, Your Honor. And as was said, you had, or the court had ordered restitution of $481,000, and it continues to have a financial impact on us. The house is not paid for, and I'm not able to retire yet. And we just respectfully request the court to enforce the restitution order, and we're just simply asking to receive what has already been determined is owed to us. And I thank you for your time and your attention, Lord. I was gonna say, sorry, I'm nervous.
That's okay.
All right, thank you.
All right, is there anything else that you would like me to know? Everything else has been fine? Okay, thank you. Status, if you can come up here and get to the microphone, please. Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
And you are Naomi Status, you are Mr. Status's sister?
Yes.
And you are his payee?
Yep.
And so you are responsible for accounting all of the income he receives and expending all of the expenditures and amounts that he owes, correct?
Correct.
And so how long have you been doing this?
He was approved in April of 2025. We did not receive any payments until I believe it was the end of July 2025.
Did he get back pay?
It comes in installments, and I believe there has been 2 installments.
And how much were those installments?
I have those records right here. Allow me a moment. In 2025, he received $12,063.27. So that includes back pay and payments that he received.
That's total Social Security?
Total Social Security for the year of 2025, realizing that he did not receive any funds at all prior to that.
Okay. And how much is he receiving a month in payments right now?
Well, as of April 10th, it says you will receive $464.10 for April. After that, you will receive $667 on or about the 3rd of each month. I have a copy of that document here if you would like one.
I take your free word. All right. And where does he currently reside?
He resides.
I'm going to ask and get some. She has a copy. I don't know if you want to give me a copy of his monthly budget, otherwise, so I can look at that. Because I'm just going to ask you all these questions that you probably already filled out before. Yes, please. All right. So here it says he receives a total of $1,014 a month.
That's true. He used to. it was being subsidized by the state of Minnesota. They asked us to renew that information in March, and we sent the information in, but my understanding is there's a backlog, and so he also is a recipient of Hennepin County Social Services, like he has a job coach, and all of those additional services have stopped. And so they may be reinstated once they process the documents. It's my understanding is it's income eligible because he is SMART certified by the state of Minnesota. So he's a person who has a recognized disability, and that's as of December 30th, 2024. And it's good until May 31st, 2027. So
Right now, he's not receiving any additional services. Is he getting any type of food share, rental assistance, those kinds of things?
none, and he hasn't gotten any of those things. And beyond his Social Security disability payments, he has received services from the state of Minnesota, but he has not received any kind of cash or something like that. I also have the case plan from his case manager that would have been accurate through the end of March, if you would like to look through the services that he's received.
I may, but for right now, is there a reason why he hasn't applied for a food benefit? He should qualify for sure.
Well, to be frank, I am a full-time teacher, and I tore my ACL, and so he only gets the help that I'm able to put through the time and effort. It's not something that he can do on his own. So
That's why we have government workers.
I am in regular contact with his case manager. Her name is Carrie through the Hennepin County Social Services, and she hasn't applied. I don't know the answer to that.
It just makes me question, because I practiced law in Minnesota for over 10 years. Plus, I know Minnesota versus Wisconsin, they have far better resources and far better benefits for people who are in need. And it's just very surprising that even on a $1,014 a month, let's just say he still gets that he's not eligible for food assistance or housing assistance or those types of things.
He works, he volunteers. It's an unpaid position, but at a food shelf every week, and they have what they call bonus. And so he brings home food from there, and he also goes through the food shelf sometimes and brings home some food.
Great, grand, wonderful. That's great. That's on top of what the state would help and assist him with, though. I'm telling you, if it's accurate, he's only going to get $667, or if he got $1,014, there's no doubt in my mind he would qualify for food assistance. Is he living in your household?
He has been, mostly because if he hadn't been, he would be homeless.
Well, and so they're probably taking in your income then, because but if you're temporarily laid off, or if you're on some type of FMLA or something, that could come into play. But he should check to see if he can apply for food assistance. But if he's living with you, you're at the Goldenrod Circle?
Yes, that's my dwelling.
All right. And so he lives with you, and he pays you $500 a month in rent?
That is
You're under
the budget.
Yeah, you're under.
That is the budget.
Yes or no? He pays you $500 a month in rent every month. Yes or no? Yes or no? Yes or no? There's no thought about it. You have it written down on this paper. You're under oath. Does he pay you $500 a month or not? She doesn't want to answer because otherwise she's going to perjure herself. It's a lie. It's a lie. You are lying to the court.
I am not,
lying
madam.
To the court.
What?
Yes or no?
No,
Yes or no?
he has never been able to pay
All
me
I
that.
need. Stop. You
Because
talk when I tell you to talk. Otherwise, you shut your mouth. You are lying to the court right now.
It's easy to see. You are lying to the court. It's a yes or no simple question. Does he pay $500 a month that you wrote down on this sheet, or does he not? The answer is no. He does not. Stop trying to lie to the court, or I will hold you in contempt and you could be sanctioned with jail. Is that your phone? Shut it off. You are lying to the court, and you have lied to the Department of Corrections. You are lying. I believe he has at least $500 a month. I'm ordering $500 a month. If he does not pay, he will go to jail. If you continue to lie, you will go to jail. You have shown nothing but dishonesty to this court. And all you had to do was answer truthfully, because I can understand his situation. I can understand his case from 2013. I can understand owing almost $500,000 and how the victims will never, ever, ever be made whole. I can understand all of that. I cannot understand dishonesty and lying to the courts. I cannot, and I will not take it. Do you understand? That is a yes or no question. Do you understand?
Yes.
All right. $500 a month. We're going to have another hearing here in June. We'll go from there, because if he had $500 a month to show on this little document that he can pay you for rent, which he is not, which is a lie, then he can pay $500 a month, and we will go from there. I will set another hearing, not one more word. June 15th at 2:00. Actually, 2:15. I'm holding 2:00 for somebody else who is dishonest with the court. June 15th at 2:00 or 2:15. I will check to make sure that he is making his payments. I will put you, if you decide to come again, I will put somebody under oath so that they know that they face perjury and contempt of the court, which could be a crime. Under oath so that I can get real and accurate and true information. And what I'm going to order then too is I want to see his banking account records. Every dollar that comes into his account, every dollar that goes out. And if you can show me that he can't afford $500 a month, at that time I will listen. Not as carefully to you because you are shown that you are dishonest to the court, but I will listen. June 15th, 2:15. Thank you. We are adjourned.
Did you see all of the people who stood up and walked out from the defense side? There were a lot of people who were invested in that one, ladies and gentlemen. There were a lot of people invested in that one. But that's all I got. That's it for the time being. Until there's going to be a few individual things popping up here and there. I got one dropping at 4 a.m. in the morning. Got another one dropping at noon tomorrow. And then we'll be back here tomorrow live for another court gallery. Man, this was a rough day. It was just progressively worse from Texas all the way to Wisconsin. So I'm not going to ham on too much about it. I'm going to say I'm your lone wolf Usul. I have brought you these hearings for your consideration from the day. And this is not all that happened. We did not even watch Thurston PPO, and there was about an hour of good stuff in Thurston PPO, which may be saved for Saturday, so keep that in mind. We'll be back here tomorrow night at 8 p.m. Central Standard Time, 9 p.m. Eastern, and I'll have a lot more for you, I promise. I'm your lone wolf Usul. I'm your curator for these here videos. I am your humble host for the Court Gallery get together where we chat, have a little forum about these videos every single day, and we are redirecting to Hutch, ladies and gentlemen. So I'm not gonna ham on. I'm not gonna ham on.
as I hammer. Y'all have a great night, ladies and gentlemen. I'm your Loma Fusel, and I will see you next time. I am out. Before I get too far removed here, I do need to tell Wixom still there's no memberships. I apologize. I see you asking about them over there. There's still no members. I apologize. Maybe one day. But for now, I want to say thank you very much, Miss Julie Sassy, for your $5 contribution earlier tonight. It is through the generous contributions of viewers like you that we can make our puppies and our mamas and our papas and our kitty bosses happy. And most importantly, thank you from the bottom of my heart. Most important, I think. Right? Y'all have a great night. Go away. There is no more. This is not a reference to Ferris Bueller's Day Off. Goodbye.